There we go. Welcome, everybody. Welcome to the Law Self-Defense Show for, well, today, Monday, February 28th. Let me take a look and make sure everything is going as it ought to be going. Thank you all for joining me again. I can't believe how faithful all of you are. So today we're going to talk about the interview done by former officer Brett Hankison in the about 2 weeks after the shooting death of Breonna Taylor. So this is still about the Breonna Taylor shooting trial. Of course, the trial has nothing really to do with the shooting per se of Breonna trial, but the events coincide, and that's how the public consciousness identifies this trial. So we'll step through all of that. The interview of Hankison that took place March 25th, 2020. So just a couple of weeks after the shooting itself. I'm going to be sharing it with you as it was played in court last week. So the interview is a couple of years old, but it was played in court before the jury in Hankison's trial just last week on February 24th. So the visual quality is not great. I'm sorry. The audio quality also is a bit sketchy. I did my best to enhance at least the audio quality. So hopefully it'll be reasonably legible. Now, what's at stake here, of course, in this case is 3 counts of wanton endangerment, what most states would call reckless endangerment. These are based on shots fired by Brett Hankison that passed through Breonna Taylor's apartment into an adjacent apartment where there were 3 people present who arguably, certainly they feel, they were endangered by those 40 caliber pistol rounds passing through their apartment. Hankison has got nothing whatever to do with the death of Breonna Taylor. His rounds did not strike her, did not kill her, so he's not facing any charge for her death. So in that sense, this trial, as I said, has nothing to do with the death of Breonna Taylor per se. But the arguably reckless shots fired by Hankison were fired in the course of executing the warrant on Breonna Taylor's apartment. So that's how we get to this point. And what we're looking for in this interview is evidence from Taylor's own testimony, Hankison's own testimony, that's inconsistent with recklessness, that would be consistent with a reasonable and justified use of force with respect to those specific rounds that went into the apartment, not other rounds fired by other officers, not other rounds fired by Hankison, because he did fire other rounds. We're only concerned for purposes of this trial with the rounds that passed into the apartment of the people living in the adjacent apartment. So before we jump into the substance of today's show, I do have a couple announcements I'd like to make. First, of course, I'd like to thank the sponsor of today's content, which is CCW Safe, a provider of legal service memberships, what many people mistakenly call self-defense insurance. In effect, CCW Safe promises to pay its members legal expenses if they're involved in a use of force event. And those expenses start big and get bigger fast, folks. It's very common in a killing case, meaning you've been charged with murder or manslaughter, to burn through as much as $200,000 or more before you even get to trial. So if you don't have that kind of money stuffed in a mattress, in case you are compelled to use deadly force to defend yourself or your family, it can be very helpful to have a financial partner standing behind you to make sure you have the resources you need to fight that legal battle the way you want it fought, as if the rest of your life depends on it, because really it does. I've looked at all the companies that offer these kinds of services, as you might imagine, and I found that CCW Safe is by far the best fit for me. I'm personally a member. My wife, Emily, is personally a member. Whether they're the best fit for you is something only you can decide. But I do encourage you to take a look at what they have to offer by pointing your browser to lawofselfdefense.com/CC. And if you do decide to become 10% off your first membership, using the discount code LOSD10. That's LOSD for Law of Self-Defense and the number 10 at that URL, lawofselfdefense.com/CCWSafe. I also have another exciting announcement I'd like to share with all of you, and that is that I've set up the option to become a member of this channel on YouTube. So you can become a YouTube member. If you look below the video now, you'll see there's a join button underneath. And if you click that join button, you'll have the option to join up at 3 different levels of membership. I'll be completely frank, and the first 2 levels are really intended just for people who feel that they'd like to contribute to our efforts to provide some generous contribution for our efforts in providing these legal analysis and commentary to you for all these cases. Certainly feel no obligation, obviously, but if you'd like to throw a few bucks our way, the first 2 levels, paralegal and associate, are really intended for that audience. The third level, the partner level, does have a benefit that the others don't, which is a bit exceptional. And frankly, it's one that's only shared with the Law Self-Defense Platinum members over at our own site. And that is that I travel around the country quite a bit for work purposes and just for enjoyment purposes, particularly on my motorcycle. And something we've never done before that we're starting to do next week, will be the first time we've done this, is to schedule in-person meetups when I'm in a particular city. So for example, next week, I'm going to be in Oklahoma City, and I'm going to be in definitely Fredericksburg, perhaps Austin, nearby. And we're going to schedule in-person meetups in both those cities for those of you who'd like to meet me in person. These are purely social events. There's no lecture. I won't be selling anything. If you have my book and you'd like to get it autographed, feel free to bring it. If you'd just like to get a photo, that would be awesome. If you'd like to come and tell some stories and share some jokes and maybe have a couple drinks, that would be tremendous. And if we get enough people to show up, maybe we'll make it an actual explicit no tie social event. So we'll see how that goes. But here's the catch. We have something like 100,000 people in the law of self-defense community between various social media platforms and our membership. And I can't have 100,000 people, or even a meaningful fraction of that, show up at some bar in Oklahoma City. So we're going to limit the announcements of these in-person meetups, or at least the details of where to meet up, to our Law of Self-Defense Platinum members and to those of you who join here on join here on YouTube as partner level members. So if you join as a partner level member, whenever we're going to a town and we'll be having an in-person meetup, we'll let our platinum members and partner level members know. Typically about a week beforehand, we'll announce that we'll be in that town. And then the morning of the meetup, we'll send a message out to those platinum and partner level members, letting them know the exact location and the exact time where we will be meeting. So if that's of interest to you, if it's not, I totally get it. But if that's of interest, you might consider joining as a partner level member here on YouTube, or alternatively, a platinum level member over at Law Self-Defense. Frankly, we would prefer that. And as a platinum level member, you also have the added benefit of being guaranteed to have my legal services available to you if you're involved in a use of force event at no cost beyond the standard platinum membership cost. So no $10,000 retainer for you. In fact, effective this year, the only way to get my legal services is to be a platinum level member. So if you're interested in that, you might want to take a look at the platinum level membership in particular. You can learn more about that at lawselfdefense.com/platinum. But if that's not of interest, you may at least consider becoming a partner level member here on YouTube. Not Facebook, YouTube. Yes, I know, I'm a boomer. I get it. Not much I can do about that. And thank you, Nathaniel Green, for joining as a member. I wonder if it tells me there. Thank you very much. I really appreciate that. In fact, I think Nathaniel is the first. You are the original plank owner member, Nathaniel. So much appreciation for that. All right, so let's jump back into this. The Breonna Taylor shooting trial, obviously, as we've already said, it involves really 3 counts of reckless endangerment towards people living in an adjacent apartment. It was 2 adults, a man, a woman. The woman was 7 months pregnant. and a 5-year-old who was living in the apartment, who's identified only by initials and court documents for obvious reasons. It has nothing to do, none of these charges have anything to do with the death of Breonna Taylor. The death of Breonna Taylor was determined to be lawful. It was not the bullets of this defendant, Hankison, who caused her death. It was the bullets of two other officers, Cosgrove and Mattingly. And I'll have a graphic to share with you to show you where the different officers were positioned. And those officers fired, well, I guess all the officers fired in a sense in response to fire coming at them. The difference between the three men is that although Covington, Cosgrove, and Mattingly fired the fatal rounds, the rounds that killed Breonna Taylor, they were shooting at an identifiable threat. Standing beside Breonna Taylor was a gentleman, Kenneth Walker, who was actually shooting at police for reasons he says he believes were legitimate and may well be so. Again, that's not really relevant for this particular trial. But because they were, those two officers, Cosgrove and Mattingly, were firing at an identifiable threat, the death of Breonna Taylor is really an unfortunate death of a bystander in the course of a justified use of defensive force by those two officers. The reason that Hanrikson is in trouble or is facing these charges is because the shots he fired that went through the adjacent apartment that endangered those three other people were, the state argues, not directed at an identifiable threat. And that's what makes them reckless endangerment as opposed to reasonable and justified. There were other shots fired by Hanrikson that arguably were reasonable and justified. Those we don't need to worry about because they're not the basis of the criminal charges here. So there are, I also want to state up front before I forget, that there was a certain, a number of factual errors I made in my coverage of this yesterday in terms of identifying some of the people involved in this drama and their roles in the drama, whether they might have been suspected of drug dealing and things of that sort. Apparently, not only was Kenneth Walker present, he fired the shots at the police, but there was another Walker present or somewhere in this drama. Apparently, the person who was actually suspected of dealing drugs was named Jamarcus Glover. He had some association with this apartment, either bank accounts addressed there or had been purportedly keeping drugs at that location. That's why there was a search warrant for the location. And I do want to, details matter, getting the facts right matter, and I genuinely appreciate the people who brought that to my attention. I will say that none of that actually matters for the purposes of this trial. So it doesn't really matter what those other people were doing or what their roles were or what their exact names were for purposes of this trial. That doesn't mean it's okay that I got it wrong, but it doesn't change any of the legal analysis or commentary of this trial, which is frankly why I wasn't worried about it very much. But I do appreciate the people bringing it to my attention, and hopefully I've clarified that a bit more. Another thing, something was brought to my attention is I had mentioned yesterday that normally when someone's facing 3 counts, criminal counts like this, from a single event, and they're found guilty of all 3. In this case, these charges of wanton or reckless endangerment are Class D felonies that carry sentences from 1 to 5 years under Kentucky law. Assuming normally, if this defendant, Hanrikson, were found guilty of all 3 charges, they would the normal practice is they would be served concurrently in parallel to each other. So it normally wouldn't be 5 years plus 5 years plus 5 years consecutively, adding up to 15 years possible max. Normally, it would be 3 sentences running parallel to each other up to 5 years. So the maximum time actually served would be that 5 years as opposed to 15. And someone had messaged me, I can't remember if it was in chat or outside of the show, but they said in Kentucky, it's the jury that decides whether or not the sentences are served consecutively or concurrently. Now, I find that a little bit surprising, but not very much, because I often say that use of force law is highly consistent across the 50 states, and it is. Sentencing varies enormously. In most states, for example, the jury has nothing to do with sentencing, unless it's a capital case, in which case they often have a role in, when they arrive at a verdict, in determining whether the sentence should be death or not. That's because of constitutional implications. But absent a capital case, normally a jury has nothing to do with sentencing. They have no idea what the sentence is. They're not making any recommendations for sentence, nothing like that. There are a couple of states that are different. I believe Virginia is one of those where the jury has a very active role in setting the sentence. I mean, basically, they set the sentence in some cases, which is highly unusual. And here in Kentucky, it was brought to my attention, or it was suggested to me, that the jury decides this issue of consecutive versus concurrent sentences. I looked it up. I checked the actual sentencing procedures for Kentucky, and the jury recommends whether it should be consecutive or concurrent, but they don't make the controlling decision. That's still left in the hands of the sentencing judge. Now, in a politically energized case like this, if the judge, might that influence the judge to be more likely to go consecutive, go for 15 years here rather than concurrent? Perhaps, I don't know. But normally when there's a single event involved, you're not charged consecutively. The thinking is they want to convict you on all three, even if it's going to be concurrent. Because what happens if you appeal and one of those counts gets reversed? Well, they still want to have you on the other two for that time. But normally it's not a cumulative type of sentence. There's also a lot of facts here, again, that, and I've touched on some of this already, that don't matter legally for the purpose of this trial. But if you read the media reports about this trial, it seems to be all they talk about. Again, this trial really has nothing to do with the fact that Breonna Taylor died. That's not a relevant fact in this case. There's no murder charges here for Taylor's death. There's no murder charges anywhere for Taylor's death. And I know there's a lot of outrage over that. There's a lot of people, there's a lot of media coverage about the grand jury feeling that they weren't given a fair opportunity to indict Cosgrove and Mattingly on murder charges for the death of Breonna Taylor. The reason they weren't is that there's no reasonable view of this evidence that would provide a foundation for murder charges under those circumstances. In effect, no reasonable, fair, impartial, unbiased jury could look at the evidence in hand and determine that that was anything other than a justified shooting in self-defense. Keep in mind, the state would have to disprove self-defense beyond a reasonable doubt on this evidence. It's simply not feasible. And frankly, it's the kind of decision that a prosecutor ought to make in not giving the grand jury the option to indict on a charge that's simply not viable at trial. That's part of the protections any of us should want in the criminal justice system. Now, it wouldn't surprise me if this prosecutor ends up paying the price of his career for having made that decision. That's what happened in the Michael Brown case, the hands up, don't shoot case. There, the prosecutor presented to the grand jury all the evidence that was consistent with the shooting being unlawful and the evidence that was consistent with the shooting being awful. And that grand jury decided not to indict the officer involved. Darren Wilson, I believe was his name. And that prosecutor had been the head prosecutor in that jurisdiction for something like 30 years, maybe more. And at the next election for his position, he lost it to a George Soros-funded candidate who immediately implemented George Soros-type criminal justice reform. So that guy did the right thing, in my opinion, in the Michael Brown case and lost his career over it. So that could happen here too. In fact, one of the prosecutors in the Ahmaud Arbery case is now being criminally, one of those that recused herself is now being criminally prosecuted on some kind of dereliction of duty charge. So, prosecutors are being trained to act in the manner the mob would like them to act. And it wouldn't surprise me if such a training experience was brought to bear here. But strictly speaking, on the merits of this trial, Breonna Taylor's death has nothing to do with it. If she had lived, these charges would have been just as legally viable. Now, in fairness, if she had lived, would these charges have been brought? Maybe not, right? Because whether they're legally viable is a question of legal merits, right? Legal analysis. Whether they're brought is a decision made by human beings and is often political in nature. Prosecutor's office has to work with the cops all the time. If nobody was hurt, no harm, no foul, maybe no charges would have been brought. Maybe there is a political dynamic here where because Taylor died, and all the frankly very misleading media coverage about that, although her there's no indication she'd done anything wrong. I mean, her death is nothing but a tragedy. But a tragedy doesn't mean it was criminal in nature. So the fact that Breonna Taylor died, that there was no good reason for it in the sense that she was doing anything wrong, even if it was technically legally justified. People are naturally outraged over that, and there's no murder charges brought for reasons I just described. So they want somebody held accountable. That's a lot of political pressure being brought to bear. Perhaps Hanrison's conduct here, the conduct the state argues is wanton endangerment, perhaps it got more scrutiny than it would have normally, because they were looking for someone they could, throw into the fire. Now, the fact that the charges may have a political component to being brought doesn't mean they're without legal merit. I mean, frankly, what I've seen so far, it doesn't look great for Hanrikson. This looks a lot like reckless endangerment to me. So, again, I have no personal investment in this defendant. It doesn't mean anything to me personally if he goes to jail or not. But professionally, from what I've seen so far, and granted, this is not one of those trials where I've watched every minute, folks, which is what my normal practice. But of course, I was covering the Curtis Reeves trial every minute last week, and I can't cover two trials at the same time. So my assessment here is limited in that respect, that I haven't seen everything, which again is my normal practice. But what I've seen doesn't look great. Okay. And that's despite the fact that much of what's being thrown around in public is nonsense and irrelevant to the facts of this case. Similarly, it doesn't matter that this was a no-knock warrant. It doesn't matter if it was a no-knock warrant and the cops announced, which is what they say and what the prosecutor says. I don't really think that's in dispute at this trial, although the media reports routinely say that there was no announcement. I'm not sure how they know. It doesn't really matter whether the warrant was defective. I believe one of the officers involved in the surveillance portion of this enterprise, who was involved in the drafting of this warrant, was fired because the Louisville PD felt he did an incompetent job in that respect. And maybe he did. But for purposes of this trial, the only thing that would matter would be whether Brett Hanrikson, the defendant, reasonably believed the warrant to be valid. If he did, it's a valid warrant for purposes of his prosecution, even if for other purposes it might have been determined, a court might look at it later and say, nope, this is no good. We're going to, exclude all the evidence acquired from this warrant and so forth. For purposes of Hanrison's prosecution, the only thing matters is if he relied on it in good faith as a valid warrant. So it doesn't matter for purposes of this trial whether or not the warrant might have been in some respect defective. Now, there are a lot of very legitimate public policy concerns that this event raises, right? Concerns about no-knock warrants, which I'm not a big fan of in most circumstances. Although arguably in this circumstance, it would have been legitimate. There was concern about drugs, which are easily disposable, which I don't find to be a compelling reason, frankly, but also guns. Keep in mind, the guns don't actually have to be there. The guns have to be reasonably suspected of being there. And if an apartment's genuinely full of bad dudes with guns at hand, and you announce police and knock before you go in, well, they're likely to take those guns in hand. And then you do have a gunfight where you would not have a gunfight had you just gone in without the announcement. So there are circumstances in which no knocks are warranted. I just feel that they're often used excessively, and they're often used sloppily. So another public policy question here is, well, was the Louisville PD routinely sloppy in its preparation of warrants? Now, that wouldn't surprise me at all. I think a lot of police departments are routinely sloppy in their preparation of warrants because normally nothing really bad happens. So they get away with it, and that practice is good enough. It works most of the time. It's easier than checking all the boxes, than dotting every I and crossing every T. So it would be human nature to kind of devolve into a sloppy but working method of doing warrants. But is that what we want as a matter of public policy, or do we want them done right, even if it takes more resources to do that? Again, I don't do public policy. I just do use of force law. But I recognize that as a legitimate area for discussion and debate. Let's see. What else did I want to cover before I dive into the interview? So really a key issue here when we listen to this interview testimony, and before we dive into the interview, I'll pause and take a look and see what what comments and questions have come in and address those before we move forward. And there's 3 places, I hope all of you know now, that you can watch these live shows. I think we've got it working. One is for Law of Self-Defense members, is at their membership dashboard. We will always answer those questions first from our Law of Self-Defense members. Then we'll answer super chats on YouTube. And those are the only ones we can answer on YouTube. I'm sorry. And then if time permits, we'll get to Rumble. We're also broadcasting live on Rumble, or ought to be. So what we're really looking for in this interview is, and of course, this is the defendant speaking for himself. So presumably, this is the most favorable version of events from the defendant. Of course, he could well be lying. I mean, who knows? But my point is, if we don't get from this source evidence consistent, or I should say inconsistent with recklessness, it's unlikely to come from any other source. So that's what I'm looking for here. And there's really kind of 3 scenarios, 3 buckets that this could fall into. One is that hypothetically, that Hanrikson was actually shooting at a bad guy with a gun, and he missed, and the bullets went on into the adjacent apartment. Under that scenario, that arguably would not be reckless endangerment, because the justification for firing the shots at the identified target would carry along with those rounds to their destination, even if the round had gone on to kill somebody. Certainly, I guess there could be civil liability, but they're under the doctrine of transferred intent, which someone asked me yesterday. This is a common law doctrine that applies in all 50 states. It's not unique to Kentucky by any means. But the doctrine of transferred intent would say the justified intent in firing at the identified target lawfully, that justified intent would carry with the bullet. And if it killed somebody, they would be an unfortunate bystander. I mean, that's basically the doctrine that's applied to Breonna Taylor. She was not shooting at police, but someone beside her was. And when the police engaged that target, justifiably, that justification of firing at, I guess it was Kenneth Walker, carried with the rounds that ended up striking and killing Breonna Taylor. So that's one bucket, that the officer, the defendant, Hanrikson, was firing at an identified deadly force target, actually had a gun, was actually a deadly force threat to the officers. Now, there doesn't appear to be any evidence consistent with that, but hypothetically speaking, if that had been the case, then there would be no reckless endangerment from the rounds that entered the adjacent apartment. A more possible scenario is that there was not actually a deadly force threat identified target, but there was something that looked like, or could be mistakenly but reasonably perceived as a deadly force identified target. And that might have been someone standing there holding a broom, for example. So you see gunshots and flashes, and there's a person, and they're holding something that looks, under the circumstances, like a rifle, and you engage that target. You're mistaken in thinking that they're a deadly force threat. They're just somebody who was sweeping the floor when the cops smashed the door in, and in shock raised it up. But you're not required to make perfect decisions in use of force. You're required to make reasonable decisions, and reasonable mistakes are acceptable if they're reasonable. So then that would be the question. When you saw that identified target, all right, it wasn't really holding an AR rifle, but could it have looked, under the circumstances, to a reasonable officer like it was holding an AR rifle? In that case, it's the same as if they were holding a rifle for purposes of justifying Hanrikson's use of force here. And that good justification in engaging that reasonably perceived but mistakenly identified target would again carry with the rounds into the adjacent apartment. There would be no reckless endangerment criminal liability there. Of more concern for this defendant, and frankly, which seems most consistent with the evidence I've seen so far, is there wasn't even that. There was nothing that could reasonably be misperceived as an actual deadly force threat. There was nothing, except maybe some flashes of light. There was no silhouette. There was no person standing there holding a broom. And this whole idea of mistakes are acceptable if they're reasonable mistakes requires that they be reasonable mistakes, not speculative or imaginary mistakes, or mistakes induced by fright or terror or stress. There has to be something, evidence, observation, something to which you applied your powers of reason to make an inference about what that thing is. You can't just imagine the threat. It's the same for civilian self-defense cases when I caution people that you can't just speculate that somebody has a knife or has a gun. Well, for all I know, he has a knife or a gun, therefore I'm privileged to shoot him. No, no, no. If you're going to shoot someone because on the grounds that they have a knife or a gun, you better have some evidence from which you're making a reasonable inference. You don't necessarily have to be right, but a reasonable misperception that would be forgivable requires the application of powers of reason to actual evidence. If they're reaching for a waistband, as if for a weapon, if they've told you they have a weapon, even if it's not true, they don't necessarily have to have a weapon, but your perception that they do, if that's the basis for your own use of force against them, has to be reasonable, meaning based on the application of the powers of reason to actual evidence. So if Hanrikson doesn't even have that, then there's no grounds for a reasonable mistake. There's no grounds to believe that his firing of those shots, the ones that passed into the adjacent apartment, could have had any reasonable basis. And a justified use of force has as one of the elements reasonableness. Folks, reasonableness is one of the 5 elements of a use of force. And again, if you're not familiar with these 5 elements, I would encourage you to take advantage of our totally free infographic. At the very least, it's just a PDF download, folks. We don't charge a penny for it. It lists those 5 elements of self-defense, provides a brief description of them. If you don't know this, you can't possibly understand use of force law. These are the building blocks of a claim of justified use of force in all 50 states and the District of Columbia and Guam and everywhere else that's a U.S. territory or state or whatever. The only possible exception, I guess, might be on Indian reservations. I have to confess, I don't know Indian law or how it would differ there. Take your chances there. But any place that most of us would be likely to be, these 5 elements are what apply. I don't care what state you're in. So you can get this at lawselfdefense.com/elements. It's free. I mean, you're crazy not to get it. I'll also say we do make a poster-sized version of this for those of you who are instructors, have a classroom. You might like to put this up. That's not free. We have to print and ship those. But if you're interested in the poster-sized version for your classroom, you can get that at the same URL, lawofselfdefense.com/elements. So the concern here for the defense is that Hanrikson had nothing from which he could make a reasonable inference that he was shooting at a threat when he fired those rounds that passed into the adjacent apartment. If that's the case, then this looks like nothing else but wanton endangerment, and he's almost certainly guilty of these criminal charges. Excuse me. And there has to be a certain amount of concreteness to all this. It can't be imaginary. So it doesn't have to be real in the sense of something substantive, like an actual person standing there. I mean, you can imagine, for example, if Hanrikson's looking through the sliding glass door into Breonna Taylor's apartment. Imagine if on the opposite wall there's a big mirror, and he looks through the door, sees that mirror, and in the lighting conditions doesn't realize he's looking at his own reflection. He sees what appears to be a person there holding a gun, and he engages that person. And of course, the bullets go clear through the mirror into an adjacent apartment. There was not really anybody there, but he may arguably have had a reasonable perception of a threat there. That would be a reasonable argument to make in court as a basis for justification. But if he has nothing but imagination, that's not good. So for the defense. So that's what we're looking for in terms of listening to him talk about what he went through. It is about an hour-long interview. So we'll go through it as best we can. If it appears to be going slow, I'll bump up the speed to try to get through it a little quicker. But that's what we're looking for. What the substantive evidence, perceived evidence is that would provide a reasoned justification for his firing of those shots, even if mistaken. All right, before I do that, let me hop to the chats and see what we have over at Law Self-Defense Dashboard. David, thank you very much for the kind words. First time in this chat for streaming here. Thank you. Thank you. I really appreciate that. And in terms of, let's see, I have to remember how to do this. Let me pull up the YouTube comments. Yeah, folks, if you want this done in a professional way, you're looking for Recital Law, I think. So let's see. Doesn't look like any super chats yet, unless I'm doing something wrong. Let me scroll through quickly and just see. Tim Horthberg, thank you for becoming a member. I can't really tell what kind of member. I'm not good at that yet, but thank you for becoming a member at whatever level you chose to become a level. There are super chats here, and they're not showing up where they're supposed to be. So here's one from Kay Vegdal. What do you think of a red dot on a handgun for home protection, or would you rather just use iron sights? I have red dots on all my guns for serious purposes, including my carry gun. My carry guns, the last several guns I've carried over the last decade or so have all had mini red dot sights on them. My long guns for home protection all have red dot sights on them. The reason is I'm 57 years old and my eyes don't see the front sight like they used to. When I was in my 20s and 30s and shooting competitively, that front sight was as sharp as you could want. It was wonderful. But when I got into my late 40s and early 50s, the front sight got fuzzy. And I'm not a fan of having those weird glasses or special glasses for competition shooting that you don't wear in real life. I want my competition gun to be my carry gun. That's always been the case with me. So I want them set up the same way and shot under essentially the same kind of circumstances. So I like the red dots on my sights. Now I will say, I will caution that there is a cost to red dot sights beyond the monetary. And that is that a handgun, at least, doesn't apply to long guns. Long guns are fine. A handgun with a dot is much less forgiving of a sloppy presentation than a handgun with iron sights. When you have a handgun with iron sights, you're bringing the gun up in front of you. That front sight's always there in front of you somewhere. It may be a little bit out of alignment, but you can see it, and you kind of incrementally bring it back into alignment as the gun comes up. If you bring up a gun with a red dot, a handgun with a red dot in a sloppy manner, that dot could be clear off the glass. It's not at all visible, and you don't know where it is. So that's one of the costs of having a dot. You need to maintain a higher level of proficiency in that presentation than you might need to do with iron sights. But that said, I'm generally a fan of red dots. What I'm less a fan of is a weapon-mounted light, like a flashlight on a gun. For carry guns, for home guns, every home gun I have, home defense gun, has a light on it. Absolutely. For carry guns, when you're not in your house, I mean, when you're in your house, there may be circumstances where it's really, really dark, like in the middle of the night in your bedroom. But if you're out in public, you're very rarely in complete darkness. I mean, if it was literally completely dark, how would a bad guy find you to attack you? So there's almost always enough light to identify a threat out in public, in a place where you may be threatened. I mean, if you don't think so, put a weapon-mounted light on your gun. It's fine with me. I don't care. But me personally, I've never felt obliged to do that. I do carry a flashlight in my pocket as part of everyday carry. So I'm never anywhere without a light, but it's usually not mounted to my gun. What else do we have here? Joe writes, my first super chat to Law Self-Defense. Thank you. Appreciate all your insight that you've shared with us thus far. My autographed copy is in the mail, so I'm counting on USPS to get hard. Yes, folks. In fact, you can still get the book on 70% off. The hardcover of The Law of Self-Defense Principles, our best-selling hardcover book. I think it's $25 on Amazon. Actually, I think Amazon only carries the soft cover, now that I think about it. So if you want the hardcover, you have to get it from us. Every one of these is autographed by me personally. I just signed another 500 books yesterday to get sent to the warehouse so they could be sent out to you. If you'd like to get this at 70% off the normal price, you can get it right now while the sale is running at lawofselfdefense.com/hard sale. Hard sale. So those of you waiting on books, we got a bunch in the pipeline now, so it shouldn't be much of a delay at all. Let's see what else we have. Tyler writes, they've announced that they'll have cameras for Jussie Smollett sentencing hearing. Any plans for you or Nick to cover this? I guess it depends on the day. In just a couple days, I leave for Texas on my motorcycle trip. I do plan on, when I take my trips, I carry a mini studio with me. So I do plan on doing shows while I'm traveling, but the timing is likely to be erratic. So I'm not sure I'll be available to do a show at the moment that the Jussie Smollett sentencing is happening. If it is, I would be happy to go on Nick's show and do it. That would be awesome. I'm sure it'd be a lot of fun. William Andrews, thank you for becoming a new member of Law Self-Defense. Nathaniel Green, did I mention you earlier? Were you the very first one? I think you were the very first member here on YouTube of Law Self-Defense. Shannon, super chat, thank you very much. Says, haven't been watching, but can you catch us up on the case based on your perspective? I think I've been doing that. It doesn't look good to me right now for this defendant. Of course, it's still the state's case in chief, right? So it's always risky to come to any kind of even a preliminary conclusion when you've only heard one side of the story. And so far, we've only heard one side of the story here. So we won't know until we hear the defense case in chief. Now, someone's told me, and of course, I get these messages and chats, and I don't know how legitimate they are. They're from people not personally known to me. Someone's told me that the only witness the defense intends to present is the defendant, which frankly wouldn't surprise me. I mean, there's a limited amount of evidence to introduce here. If the state's really brought to the jury every other witness, who would be left really but the defendant? But I think for sure the jury's going to need to hear from this defendant, his perceptions. And of course, anything he says in court is going to be compared and contrasted with what he said in the interview we're going to go over here today. So I would expect his testimony in court can't be very different than what we'll hear from his interview with the Public Integrity Unit just a couple weeks after the event. Ginger7681, thank you for becoming a member. John Turlington asked, does adding mods to a gun make them a problem if they end up in court? Well, anytime someone asks me, can X be used against me in court, the answer is always yes, because prosecutors can say almost anything they want in court. At least you have to assume they'll be allowed to. Maybe a judge will exclude something, but that's up to the judge. You can't count on that ahead of time. So just assume that a prosecutor can use anything against you. In the George Zimmerman case, they argued to the jury that Zimmerman must have acted with malice because not only did he have a gun, he had a round in the chamber of his gun. Well, everybody carries around in the chamber their gun if the gun's being carried for self-defense purposes. Israeli carry aside, let's not get into esoterics. So a perfectly normal, every bailiff in that courtroom that was armed had a round in the chamber of his gun. That's normal. But the prosecutor tried to make it seem abnormal. So can they talk about this stuff? Yes. The real question is, how damaging is it likely to be, and how readily can your defense attorney mitigate that damage? A round in the chamber, in the Zimmerman case, the defense didn't even bother trying to mitigate it. They didn't try to counter it at all. It was that ridiculous. And so when I think about modifications to a gun, I think about the ones that are likely to be damaging to you. And I don't worry much about the ones that are not likely to be damaging. And the ones that are damaging are the ones that go to your state of mind. They suggest malice of some kind, or they change how the gun fires, mechanically fires. So things that go to state of mind are things like, if you engrave "kill them all, let God sort them out" on the slide of your pistol, or you put a Punisher backplate on the back of your Glock, or you put "look for flash" on the muzzle crown, or you put "you're effed" on the ejection port cover. Those are all things that go to state of mind. By the way, same for things like your car. You put a bumper sticker on it, "keep honking, I'm reloading," that kind of thing. "We don't call 911" signs in your home. These all go to state of mind. They're statements to the public. I know we mean them as jokes, but that's not how a prosecutor will present them, and it may not be how a jury perceives them when the prosecutor describes them. The prosecutor is going to describe them as, hey, we know what your state of mind was because you've told us. You're telling us. You're above the law. You have that Punisher backplate that you put on your gun. Glock doesn't sell them like that. You put that on your gun because you perceive yourself as a vigilante who's above the law, which is what the Punisher comic book character is, right? You don't want that. You don't want anything that can suggest a negative or criminal or malicious state of mind. So please don't put messages on your gun. And in terms of how the gun fires, I would absolutely never disengage any kind of safety in a gun. If you have a 1911 with a normal grip safety and it doesn't work well for you, so you pin it in place or tape it in place, don't do that. If there's a magazine disconnect in your gun and you don't like that and you disengage that so the gun will still fire with the mag out, don't do that, because you'll never convince a jury that you know more about what that gun requires in terms of engineering or safety mechanisms than the engineers who designed the gun. Plus, by the way, and I would also mention things like really lightening a trigger. So a typical Glock, for example, comes with about a 5.5 pound trigger. You put in a drop-in trigger kit that lowers that by half to 3 pounds or even 3.5 pounds. That's a big difference. That's noticeable, which obviously that's why you're doing it, right? Because it makes a big difference and it's noticeable. But it opens the door for a prosecutor to argue that, this shot you fired wasn't really intentional. It was a negligent discharge. You unintentionally fired that gun. And frankly, if you drop the trigger weight by half, maybe you did unintentionally fire the gun, right? It makes it more likely the gun will be fired unintentionally. So my advice is don't do those mechanical modifications to your gun that change how the gun fires. There's so many good concealed carry guns out there with a variety of features. Just buy the one that has the mechanical features you like and leave them alone. Now, there are modifications you can make that don't affect how the gun fires. Things like the sights, things like stippling the grip. I don't care about those at all. Do whatever you want with those. And by the way, I don't care about any changes you make to fun guns. If you have guns you only use at the range, do whatever you want with those. I'm only talking about guns that might be used for serious social purposes. Let's see. What have we got? JD writes, I carry appendix. I found the P365 XL grip was taking the skin off my belly like sandpaper, so I had to wrap the grip with electrical tape to alleviate the problem. Do I have a problem with that? No, that doesn't change how the gun fires, so I would not have a problem with that. Either making the grip more aggressive so it locks in the hand tighter, or taking off some of the texture so it's not as abrasive. Yeah, I've carried guns that would eat through my clothes. Eat through my jackets when I wore them concealed. So that had to be adjusted, obviously. But I don't worry about that kind of thing. It doesn't affect how the gun fires. It's not a statement as to your state of mind. Okay, so that was the super chats. Quick look back at the members. Maybe it's time for a new computer. Okay, I'm going to move on from there. What do we have for? Someone's upset at Rumble because I have these training grenades, rifle launch grenades on the shelf behind me. Those are the things with the blue tops. They're completely inert, folks. They were fired 15 years ago. I collected them at the range at the Sig Sauer Academy, actually, when I was teaching there. I'm sorry you feel that they represent that. I think life is devalued. I don't know. Save those tears, and soon you'll have a bucket full. Okay, so with that out of the way, I think we're all good. So here's the, let me share quickly just the indictment. Just for a moment, so we can take a look at that quickly. And I will embed this indictment in the text version of today's content, which is available to Law Self-Defense members. But here we have these 3 charges. So count 1, wanton endangerment in the first degree with respect to CE. That was the adult male in the next apartment. Count 2, wanton endangerment in the first degree with respect to CN. That was the adult female in the adjacent apartment through which Hanrison's bullets flew. She was 7 months pregnant at the time. And count 3, wanton endangerment in the first degree with respect to ZF, who was a 5-year-old child. So this victim, has only ever been identified by initials. And I also have here a graphic prepared by the New York Times of the event. Now, I caution anything prepared by the media has to be presumed to be wrong until proven otherwise. The media lies about use of force events all the time. I certainly would not put it beyond them to create a misleading graphic of this event. But with that said, it appears on at least superficial review that this is something like a reasonable representation of what happened. And what this is a graphic floor plan of the apartment. It has these orange lines that represent the shots fired by the police officers, including Hanrikson. And I've annotated this graphic with text to show where the various parties were positioned with respect to the apartment, which the original graphic didn't really do. The one the New York Times prepared is actually a GIF, so it's animated. It purports to show the sequence in which the shots were fired. I'm just using a still shot of that graphic here, arguably fair use. But in any case, I do credit it to the New York Times. Other than the annotated text, this is not my creative work. So let me pop that up on the screen. So we see here, we have this apartment on the left where it says Mattingly and Cosgrove. Those are the two officers who breached the door. On the far right, Taylor and Walker, they're down a corridor here. At the far end of the corridor, at least that's where Breonna Taylor's body was fired. So we have good reason to believe that's where they were located. Within line of sight of Mattingly and Cosgrove, and of course, they were in line of sight of the officers as well. The door comes down. Walker fires a single round at Mattingly, hits him in the femoral artery. So a life-threatening wound. There's a lot of blood outside that door. So he's pumping out blood hard. Very fortunate to not have bled out right there. He was saved ultimately. Presumably they put a tourniquet on him. Definitely he got surgery to save his life. Despite having been hit in the femoral, by the way, he returned 16 rounds, or maybe because of being hit in the femoral, he returned 16 rounds. Cosgrove fires 6 rounds. And you can see the rounds are mostly in the direction of Taylor and Walker. There are rounds that go errant. When you're firing a fusillade of fire, not that unusual. I mean, I wouldn't say these are good things. These ones off to the angle like this, that shouldn't be happening. But none of these were felt to be the grounds for reckless endangerment. I believe probably because they were all captured inside the apartment. So Mattingly and Cosgrove firing at Taylor and Walker after Walker fired at them. And this is the shooting by the officers, Mattingly and Cosgrove, that was deemed to be justified self-defense. They took an incoming round. They were actually strike. Mattingly with a life-threatening wound. They returned fire. And that fire unintentionally also only struck Breonna Taylor with fatal effect. But because they were firing at an identified target that had shot at them, that was a justified use of force in self-defense. So although Taylor died, that's a tragic event. She wasn't doing anything to the officers to threaten their lives. She just happened to be in the wrong place at the wrong time, standing basically in front of the person shooting at the police. By the way, Walker says he had no idea they were the police. He thought it was some kind of home invasion, and that could well be true. In fact, ultimately, the charges against him, he was initially charged with firing at the officers. Those charges were dismissed. That happens. If you genuinely don't know the people coming in are police and you reasonably believe them to be some kind of home invasion, you deal with them as you would deal with any home invasion. But obviously, when you do that, when you shoot at police, they tend to shoot back. And that's certainly what happened here with a bad outcome for Breonna Taylor. But because they were engaging an identified threat, their use of force was deemed to be justified, even though it had the unfortunate effect of killing Breonna Taylor. Hankison, the defendant here, was actually outside the apartment. So there's like a balcony with a railing. I believe he was on the opposite side of the railing. He was looking through a sliding glass door here on the left and a window here on the right. And he fired basically 2 streams of bullets. The way the New York Times animates this, the stream on the right is fired first, and then the stream on the left. These are the more vertical orange lines. The stream on the right arguably would be as justified as the fire of Mattingly and Cosgrove. There was a door here, but it was open. Of course, we know that because the bullets didn't pass through it. And they were directed at Taylor and Walker, who could reasonably be perceived as deadly force threats to, if not to himself, then to his fellow officers. You're allowed to use force in defense of others. The troublesome part is the shots on the left. These vertical lines on the left. At the top here, it says victims. Those that represents obviously Breonna Taylor was a victim of this event. But for legal purposes of this trial, the 3 victims in the adjacent apartment, that these rounds, 3 of these rounds, well, maybe more than 3, 3 victims is why there's 3 counts. These rounds passed through Breonna Taylor's apartment onto the apartment of the 3 victims. These are the troublesome ones. And here's the difficulty, at least based on this illustration. These rounds are nowhere near the actual threat. I'm not aware of any evidence that there's anything here that could reasonably be perceived as a threat. Now, again, I guess if there was a mirror on the wall here, but I don't believe that was the case. But you could imagine if there was a mirror, Hankison might have looked through and seen something that looked like a person with a gun, right? That could be a reasonable mistake, a reasonable misperception, nevertheless sufficiently reasonable to justify the use of force. But I don't think that's the case. And by the way, here's our other officers right on the outside of this door. I mean, could you make an argument that these rounds recklessly endangered his fellow officers? Frankly, I would think you could. But I guess the state decided not to go that way. Maybe because the other officers, I mean, they're voluntarily engaged in a dangerous enterprise, right? They're going to execute a warrant. So you could say they kind of consented to the risk of getting into a gunfight. I don't know. They know they're going to a gunfight or a potential gunfight. The victims are just in their home, right? Watching TV, getting ready for bed. They didn't volunteer for any of this. The cops kind of volunteered. Now, I don't think that's a very compelling argument. I think the cops volunteered to do things that are dangerous, but in the expectation their fellow officers would not act recklessly towards them, that they would act, competently and reasonably. But nevertheless, for whatever reason, the state decided to not charge reckless endangerment with regard to the fellow officers, but only to those 3 victims. So when this is the layout and these are the trajectories, this group here on the left looks really hard to justify as reasonable. And that's the difficulty I see for the defense here. Okay, so let me see. Before I start the video, which I am going to start in just a moment. Whoops, that's not what I wanted to do. Let me try this again. Before I start it, I'll take another quick look for comments. Okay, and now the more formal super chat way looks to be going well. Anti-Kami asks, delivered a few books of yours in Zion, Illinois, of all places. Wanted to check out using USPS Media Mail to cut some cost for your customers. Normally, when we ship the free books, they're normally Media Mail because, well, they're free books. The hardcovers, I think we normally ship first class because people paid for those books, so we want to get them there in a reasonable time. Media Mail can take a while sometimes. Professional AF Farrier asks, thank you very much for the very generous super chat. These are all super chat comments, by the way, folks. Those are the only ones we can answer from YouTube. I'm sorry. Otherwise, we do nothing but. What are your thoughts on NFA devices used in self-defense, not as a plan, but as a last resort? The first thing you grab in a home invasion. So if by NFA device, you mean things like a suppressed weapon or a machine gun, presuming the items are lawfully owned, I don't see any problem legally. Now, is it something a prosecutor could talk about? Sure, he can talk about it, just like he can talk about you having a round in the chamber. Is it likely to be damaging? Maybe a little more. I mean, machine guns are unusual. Suppressors are unusual. I usually discourage people from using unusual things in self-defense, but there's nothing in the black letter of the law that makes it unlawful to do that. I'm not sure how much advantage you get, frankly. I don't think I would use a full automatic for self-defense. A suppressed weapon, I don't know. I'm not sure. It's on a pistol, definitely not. It just makes the pistol too unwieldy. On a long gun like an AR, I've heard different views on it. I don't think I would. I actually want the noise and flash directed at the people intruding into my home. But I know other people feel differently, so personal choice. But there's nothing unlawful, assuming the suppressor is lawfully owned in the first place. There's nothing unlawful about using it for self-defense. Sheldon asks a motorcycle question. Any opinion on the BMW F800 GS motorcycle? I've never ridden one, so I don't have any opinion. I did look at them once, and it seemed to me that they weren't all that much lighter than the 1250 GS, than the big GS. So I've always stuck to the big one. All right. And I don't think there was anything else from the members. So let's go ahead and start this video. Now, the quality is poor because this is how it was presented in the trial, in the courtroom. I've seen clips from the original video in much higher quality, but I was not able to locate it. So this is what we're stuck with. I did run the audio portion through an optimization process, so hopefully it's better. It starts pretty quiet at the beginning because I think they're at a distance from the microphones, but it should get better when they sit down. So let's see. I'll make that a little bit bigger there, and let's go ahead and get started. Where is it? Here we go. No, I just and I did speed it up. I do have allergies, so I cough. I did, but you also Kleenex or not? You know what? That's a little hard for me to hear. So let's start it at normal speed and see what happens from there. We have allergies too. Crazy the past couple of days. You don't get anything before? Yeah, at the old building. Okay. The ones that we don't even have the building. Your President, 3672 Taylor Boulevard at the Public Integrity Office. This will be a recorded statement from Detective Brett Hankison. The statement is in reference to PIU case number 20-019. Present with me are Detective Brett Hankison and Attorney Steve Shoring and Sergeant Jason Vance of the Public Integrity Unit. Detective, are you aware that this statement is being video and audio recorded? Yes. The statement for approval? Yes. Please state your full name and spell your last name. Brett Hankison, Hankison. What is your code number? 6150. Where are you currently assigned? The criminal interdiction division. How long have you been with that unit? Since I was created maybe a few months ago. And how long have you been with the department? Since 2003. Are you under the influence of alcohol, drugs, or any other intoxicant at this time? No. Are you taking any kind of medication that would affect your judgment or ability to think clearly? Yeah. The next several statements will be in reference to the incident that you're here for, March the 13th. That's from the Springfield address. Did you sustain any injuries during this situation? No. Did you receive any medical treatment? No. What type of uniform or clothing were you wearing at the time of this incident? I was wearing an LMPD tactical vest, and I believe on the front of it says Police K9, and I believe it says Police again. It's the heavy duty units that were issued. You have on the same uniform and clothing right now? I do not. Because the statutory requirements of KRS 67C 326, I'm obligated to advise you of your constitutional rights prior to making any further questions. On the back question, sorry. I also have a full gun on too, like the taser or like just okay. It doesn't have any other identifiers on it. Okay. Before we ask you any questions, you must understand your rights. You have the right to remain silent. Anything you say
and will be used against you in court of law. You have the right to talk to a lawyer prior to any questioning or making of any statement, and you have them present with you while you're being questioned. You cannot afford to hire a lawyer or one will be appointed by the court to represent you before you question if you desire them. You may stop the questioning or making of any statements at any time by refusing to answer further or by requesting to consult with an attorney prior to continuing the questioning or making of the statement. The bottom by you signing this, you read the statement, you will be right to understand what your rights are, you may need to make a statement and answer questions. You have a lawyer with you present at this time, you understand what you're doing, no promises or threats have been made to you, and no pressure or coercion of any type have been used against you. So like I said, this is about the incident that occurred on March 13th, 2020 at 3003 Springfield Drive, apartment number 4. In your own words, just let us know what happened, what kind of police action that you took, and
The March 13th was actually my regular day off. We were advised earlier in the week by, I think, the police-based platoon sergeant that they were planning an execution for at least 4 search warrants on that night. The sergeant was requesting bodies. He was also.
All right, you know what, folks? I didn't realize how awful the audio quality was going to be. I don't think I'm going to make any of you endure all this. So what I'll do is I'll see if I can't find the original version of the file that's at least visually was of much higher quality. I assume the audio quality is much better as well. And certainly when assuming that Hanrikson does testify himself, and I believe he is intending to testify in his own defense, we ought to have that ought to be his side of the story, and we ought to be able to capture that from the live court feed as the trial is occurring right now, rather than go through this nonsense. It's ridiculous. So with that said, I'll just open up the floor to any questions anybody might have on other matters, whether related to this case or other cases or use of force law generally. I can take 10 or 15 minutes to kind of make this an open Q&A session. Again, I will remind everybody, for those who came in late, a couple of, an announcement we're really excited about. We now offer memberships on YouTube. You'll see a little join button below the video. We have 3 levels of membership: paralegal, associate, and partner. Paralegal and associate is really just for people who'd like to throw some money our way in appreciation for our efforts in providing all this legal commentary and analysis and education and hopefully some jokes. That's much appreciated. Don't feel obliged, but if you're so inclined, that would be a great way to do that. The partner level is different. The partner level is going to put you in a category where, as we move forward with our new initiative of having in-person meetups when I travel to different cities, the partner level members and our own platinum members at Law Self-Defense will both be invited to in-person meetups. So this week, actually, the end of this week, I'll be in Oklahoma City, and I'm going to arrange an opportunity for an in-person meetup while I'm there. That'll be on Saturday, probably late Saturday afternoon or early Saturday evening in downtown Oklahoma City. And what we'll do is the day before or the morning of Saturday, I'll send out a message to all our platinum and our partner level members on YouTube about exactly where and when we'll have the opportunity to meet up. So I'll be there. You'll know it's me because I'll be wearing a tie. And these are completely informal gatherings. There's no lecture. I won't be selling anything. It's just an opportunity to meet in person, tell a few stories, tell a few jokes, maybe have a couple drinks. And maybe I'll set some kind of threshold where if we get a minimum number of people to show up, maybe 20, the tie will come off and we'll make it a no tie event. We'll see what happens there. I wouldn't expect things to run too late. I'm old. I have a bedtime. And Sunday morning, I have to get on my motorcycle real early and leave Oklahoma City to head down to Junction, Texas, which is a pretty good ride. But we'll spend a few hours together on Saturday afternoon. That's for our Law Self-Defense Platinum members and the partner level members who join us on YouTube now that we have that option available. And with that, let's see if there's any new. There is a couple super chat questions, so let me pull those up. Yeah, Law Self-Defense member David says, full auto is fun at the range, but I wouldn't want one for self-defense, assuming I'm not up against an army. Yeah, I think that's right. Or pirates, if you're on a boat at sea, I could see utility there. But the circumstances in which you're really getting return on investment for that full auto when it's used in self-defense seems to me to be pretty limited. And by the way, very easy to end up using in a manner that could be characterized as reckless. I've fired a lot of full auto guns in my time. I've had, just based on life experience opportunities, especially at the FBI Academy. When I teach there, invariably they invite me to the range and they pull out all kinds of guns. Tommy guns from the Prohibition era. Those are a blast to shoot. But some of these guns, those full auto guns, can be difficult to control on full auto. So you don't want to be firing uncontrolled shots for sure. All right, so let's see with the super chats. Try this again. You know, this YouTube interface is not great. Andre Blanchard asks, and thank you for the super chat, do you have the right to self-defense if you're under the influence? Obviously, you shouldn't be in possession under the influence. Well, whether you can be in possession under the influence is a matter of state gun law. Some states are more stringent about that than others. So that's really a separate matter. Do you lose self-defense, or is your privilege of self-defense constrained if you're intoxicated? Now, keep in mind, when we're talking use of force law, we're really talking independent of the weapon involved. I don't really care about the weapon. If you're drunk and you have a gun and your state says that's a crime, you could be facing a gun charge there, but that's different than whether or not there's any impact on your privilege to act in self-defense. We're all on the same page there. Gun law, different than use of force law, okay? Except with one kind of overlapping component I'll come back to in a moment. You don't lose your privilege of self-defense just because you're drunk. You have exactly the same privilege of self-defense as you did before. But here's the thing. You're also held to the same standard of reasonableness. So voluntary intoxication doesn't get you anything in any aspect of criminal law, much less use of force law. So if you act in self-defense and you happen to be drunk and you're making, nevertheless, reasonable decisions in self-defense, it shouldn't make any difference in your claim of self-defense. If you're drunk and you make bad decisions in self-defense, well, then you own those bad decisions. And if those bad decisions were unreasonable because you were drunk, well, then they were unreasonable. And if they were unreasonable, they don't qualify as justified self-defense. So it's not that you lose self-defense because you're drunk per se, but to the extent you make bad decisions because you're drunk, yeah, of course, that could damage your claim of self-defense, just like if you made bad decisions when you were sober, you could damage your claim of self-defense. Now, one place being drunk and in possession of a gun could impact your claim of self-defense is if you're in one of the stand your ground states. There's roughly 39 stand your ground states. About half of them are stand your ground by statute. The other half is stand your ground by case law, court law, appellate court law. The ones that are stand your ground by statute, many of those have as a condition of qualifying for stand your ground. Of course, stand your ground properly understood simply means you're relieved of that otherwise existing duty to retreat, if the state has that. You're relieved of that element of avoidance. But in many states, you have to qualify for that. You have to meet conditions to be relieved of a duty to retreat. And often one of the conditions is that you're not engaged in unlawful activity. So if your state has a law that says if you're drunk, you can't be in possession of a gun, and you are, arguably you are engaged in unlawful activity. You wouldn't lose self-defense generally, but you might lose stand your ground and reacquire that legal duty to retreat. Now, that shouldn't really matter. Let me get rid of this stupid, I forgot the screen share was still there and I'm not using it. That shouldn't matter. Good guy cases of self-defense, because most good guy cases of self-defense, if you have a say rather than get into a gunfight, you'd be a fool not to take advantage of that. So I'm a fan of stand your ground laws. I think they're the right public policy, but in most good guy self-defense cases, it's not really relevant to the facts of the case. Most normal people will safely retreat before they get into a gunfight. So it tends not to be an issue as a practical matter. So that's the intoxicated self-defense perspective. Evil Bunny, thank you for the very, very generous super chat contribution. Says, you said you'll be in South California soon. Do you mean LA, or are you actually going to be in San Diego? I'm going to try to be in both. This would be, I have a number of social obligations centered, well, really it's centered in Las Vegas, but I have friends in LA and I have friends in San Diego. So I'm going to try to make it a broader trip after I've met my social obligations in Las Vegas to proceed to Southern California between LA and San Diego, hit both of those cities. So that's my plan at the moment. When we have all that solidified, I'll set up in-person meetings in those cities as well, and let our platinum members and our partner level YouTube members know where we can meet up and meet in person, take some photos. If you bring a book, I'll sign a book. I won't be teaching. I won't be selling anything. It's just purely a social occasion. But I'll let you know about those as we get those pinned down. And any platinum or partner level members who'd like to show up for that, more than happy to meet you in person. That would be awesome. And if there's no more, questions, I think that's the members. And I think that's the super chats. Oh, no, another super chat. All right. Casey, thank you for your super chat contribution. Says, Mr. Branca, my high schooler is writing a paper on self-defense. What should she include that would be helpful for her or her classmates? Frankly, I think the best thing you could do for her, I mean, I'm not sure exactly what what facet of it she's taking, but there is no self-defense without those 5 elements of self-defense law. The best thing you can do for her is just get the free PDF download, and at least that'll give her a framework for discussing self-defense if she's discussing it from a legal perspective as opposed to, I don't know, a moral or societal perspective. But for a use of force to be valid self-defense, it has to meet these 5 conditions, at least up to these 5 conditions. There are no more than these. There's not 500 elements of a claim of self-defense. There's not 50. There's only 5 at the most. And often one or more of these is legally waived, so it's not even required. So in the majority of states, the 39 states that are stand your ground states, avoidance is not required in otherwise lawful cases of self-defense. So then there's only 4 elements of a claim of self-defense. But if she doesn't at least understand these 5, she really can't understand self-defense from a legal perspective at all. And the nice thing about this framework is it does apply in all 50 states. So anybody, including your daughter, can get this at lawofselfdefense.com/elements for free. It's just a PDF download, folks. It doesn't cost a penny. All right, so I think that's about it. I think we'll go ahead and wrap up, folks. It's been almost an hour and a half. Thank you all for spending your time with me. I really appreciate it. We'll follow up more on this, either the interview by Hanrikson a couple of weeks after the event, or his live in-court testimony if he does testify in his trial before I leave for Texas. We'll cover that as it happens in real time. And I'm sure we'll come up with something to talk about tomorrow in a live show as well. As someone said in the comments, indeed, I'm working overtime to pay for my wife's Disney trip we're taking in a couple months. So those don't come cheap, folks. So thank you for all your contributions. I personally greatly appreciate it. And so will Mrs. Branca. Emily will appreciate it as well. All right, folks. Until next time, I just want to remind all of you that if you carry a gun, so you're hard to kill, which is why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself to make sure you know the law, so you're hard to convict. And I don't mean by legal tricks, folks. We don't teach legal tricks. We are, of course, a law practice. We do legal consults and self-defense cases, but really the core mission of law self-defense is to be transformative, is to put your mind in a better position to make better informed, more confident, more decisive decisions in self-defense because you really know where the actual legal boundaries are, and therefore you needn't step over them out of sheer ignorance and put yourself in serious legal jeopardy because of that. That's our mission. We want to make you harder to convict because you know the actual law. All right, folks, until next time, probably sometime tomorrow, keep your eyes open for notifications. I remain Attorney Andrew Branca for Law and Self-Defense. Stay safe.